I think if you decide to admit your crimes over a beat, I'm going to use it. I'm not targeting anyone, but however, you do not get to commit crimes in my county and then decide to brag on it, which you do that for a form of intimidation and to further the gang and not be held responsible.
That was Fulton County District Attorney Fannie Willis during a press conference justifying her push to allow for the admissibility of song lyrics in the criminal conspiracy case against Jeffrey Lamar Williams, alternatively known as Young Thug, a well-known gangster rap artist. Before the trial, Young Thug and more than 20 of his co-defendants were indicted on 56 different counts of criminal activity. Williams often sings about allegedly participating in illegal activities and puts forward the persona of a gangster to help sell his songs, albums, and concert tickets. While this may have helped him fit into the gangster rap scene, this has become a liability as the Fulton County Prosecutor's Office has moved to have these lyrics admissible in a felony conspiracy trial as evidence against him, a move granted by the Fulton County Superior Court Chief Judge Earl Glenvale under the condition that the prosecutors prove a connection between the specific lyrics and the crimes alleged in Williams' indictment. Already, some of Young Thug's lyrics have been admitted to the court as evidence, and its use has been approved by the judge. This seems reasonable. So why is this controversial? I'm Cole Brockman, and welcome to the first episode of Jury Prudence. In this podcast, we talk to legal experts and professionals to teach and inform you about the ins and outs of the American justice system. In this episode, we will be going over some of the legal controversy surrounding the Young Thug trial and why it is a controversy in the first place.
There's no requirement that what you sing about be true. I wouldn't be surprised at all if some of them have lived in areas and had experiences directly related to gangs. But does that make them guilty of criminal activity? That the rap lyrics would never be sufficient to prove that.
That was Dr. Lori Johnson, a political science and law and public policy teacher at Mercer University. She got her JD at the University of Virginia and has an active law license in the state of Georgia. While Dr. Johnson is not an expert in conspiracy law, she gave some valuable insights into what was happening in Williams' trial. She states that the main controversy surrounding the admission of song lyrics as evidence is if it is prejudicial or probative evidence.
Probative means it goes to prove an essential fact in the case. Prejudicial is that it undermines the defendant's credibility in ways that are not seen as fair.
The judge will make the consideration for whether the lyrics are more probative or prejudicial as the lyrics are submitted to the court as evidence, but the controversy that they are even considered evidence at all builds with the controversy of the conspiracy charges as a whole, as this could affect more than just Williams' case.
I think the way conspiracy laws are used in our criminal justice system is something I've studied and read about. I think that they're often this net that wraps in people who may or may not have been involved in illegal activity too. So while the goal of conspiracy law makes sense, the use of it has certainly been criticized by other people.
Young Thug is charged with murder, kidnapping, armed robbery, motor vehicle hijacking, assault, various drug-related charges, gang activity, and criminal conspiracy under Georgia Statute 1614-4, the Racketeer Influenced and Corrupt Organizations Act, or the RICO Act.
Originally, RICO laws, Racketeering and Corrupt Organizations Act, were designed to get at the mafia. Organizations that were created and existed for the sole purpose of engaging in illegal activity and facilitating that illegal activity. And those were hard to prosecute individually. But if you can get an indictment against all of these people, then you can try to get them to turn on each other and take plea bargains and testify against each other.
This collective bargaining power is integral to many criminal conspiracy cases like the one against Williams. Dr. Johnson compared it to a tactic used in civil disputes, the class action lawsuit, where multiple plaintiffs sue together to have more collective bargaining power over the defendant. Only the roles are reversed in RICO charges. The defendants are at a disadvantage because there are so many of them. Yet, if this is so common, Why is it important to Williams's case, and what does this have to do with song lyrics?
Probably the better example that always gets used is if you were the lookout, right? Like you didn't go in the bank, you didn't hold a gun on anybody, you didn't ask for money, but you were on the outside watching to see if anybody came. But with conspiracy, if you were the lookout, you would be responsible not just for that crime, but all the other bank robberies that those particular defendants had engaged in, whether you were the lookout for them or not.
Here's the kind of social math these RICO cases work on. First, find as many people related to a crime ring as possible. Second, arrest them on whatever you can get them on, let them know you have or make them think that you have someone else in the ring with information about their crimes, and that they can get charged with more crimes that they are not even involved in. Third, offer them a way out by ratting out other people involved in the organization. They'll get a lesser sentence through plea bargaining, the police get more information on the people higher up in the criminal organization, and those with less involvement who have the information get to walk away. Or that is how it's portrayed. In reality, not everyone knows everything about an organization they're involved in, and this method of charging people with the full extent of the conspiracy encourages people to name as many people as they can think of, even if they don't have anything to do with the criminal conspiracy at all. But why is prejudicial evidence seen as so unfair? If it does not prove anything, how could it be used to affect the case? There's a joke on the internet where someone contacts a product seller and they say they've not received the item they've ordered. And the seller then asks for proof. The buyer sends a picture of their empty hand because how can you prove you did not receive something? Similarly, Williams and his attorney have to prove that the song lyrics are not indicative of what he's done. Williams' attorney has to prove a negative, which is hard to do. The initial controversy of Williams' trial is that the defendant is such a well-known figure, and his associates were brought in and got more charges because of how conspiracy law works. These potentially unfair tactics and the fame of Williams are why the case was initially so controversial. The admission of song lyrics as evidence is like throwing gasoline on the fire. The probative quality of the lyrics is minimal at best, but their prejudicial quality could be quite high. This gets worse when looked at in the other cases. The song lyrics may or may not be admissible in their trials, but its admission into Williams' trial does not make them look good by association, and this is hardly a new issue. Eric Nelson and Andrea L. Dennis state in their book, Rap on Trial, and in later interviews, that there have been hundreds of lesser-known cases where rap lyrics were used in a similar manner. They also claim that rap is the only musical genre to be used like this, referencing how Johnny Cash was never charged with murder for singing, "I shot a man in Reno, just to watch him die." But it isn't just the judge who should be making these decisions as to whether circumstantial evidence like this is probative or prejudicial. The jury should too, but these controversies are often poorly explained in a court of law. Young Thug's trial began in late 2023, and it is unclear how long the trial will last. Thank you for listening. I'm Cole Brockman, and this has been Jury Prudence.